case to come before the court is State versus Hickman. Good morning.
Good morning, Your Honor.
You both will now have 15 minutes to argue your cases, and you, as the appellant, may reserve up to 5 minutes if you so choose.
Thank you, Your Honor.
Just let me know when we're ready to proceed anytime you want.
Thank you, Your Honor. Your Honors, Court, I'm Attorney Dan Bache. I've just filed a notice of appearance in this matter on behalf of Defendant Keith Hickman, standing with co-counsel Jason Wallace, who cannot be here. At this time, we would like to reserve 3 minutes for
That's fine.
Your Honor.
Thank you.
Thank you. Your Honors, there's basically two matters that we want to focus on today, and that is whether or not Mr. Hickman was afforded a fair trial in this matter, and that his due process rights under the 6th, 14th Amendments to the United States Constitution, Article 1, Section 10 of the Ohio Constitution, were abridged when these assignments of error occurred during the trial, Your Honor. And then the second matter we really want to focus on is the sentencing, and that the court abused its discretion in imposing the appellant's sentence. Your Honors, there were many years in this trial, first being when the defendant was in the court, and the victim was, first off, the victim in the beginning of the trial was downstairs making his case known before the jury even got pulled. And he was relaying all his side of the story to all the jury members, and this was later relayed to defense counsel. Secondly, Your Honors, the court, forgive me, I ran here. The court did not hold the victim when he was on the stand to court standards. He was abusive to the defense attorney. When he was in the when he was making his witness statements, he always afforded the prosecution. His memory was solid, and then when he was arguing with the defense, he was contrary, couldn't remember anything, and was verbally abusive to defense counsel. During this time, the court did not hold him in contempt or anything to that effect. However, their tacit endorsement of his behavior to defense counsel, despite repeated warnings from the court, showed that the jury, or could be implied to the jury, that the court endorsed his behavior and therefore reflected poorly on Keith Hickman. Third, when the jurors were deliberating and prior to the jury verdict, it was noted that one of the jurors in the back had actually done research outside the court's approval. And every time the court would move for a break or anything in this trial, the court would admonish all of the jurors, listen, you cannot do outside research on your own, nothing can be brought in or anything to that effect. However, this juror had done his own research, and even by his own admissions, he had looked online to find out information about the case, and then all the parties agreed, other than the juror himself, that when he did this research, he did more than just click to find a name, which is what he alleged. He found out that there were subpoenas, and he done more research in the case. To that end, Mr. Hickman cannot be assured that he did not use that information to go forward into the jury and make his arguments go forward to the jury members, and therefore taint the deliberation with outside influence, because all of the information should have come directly from what was in the trial, Your Honors.
Well, I know that nobody's really contesting that he did look on the clerk of court's website and look up the case, at least the case name and whether he clicked on it. Looks like there's some reliable information that he might have clicked on it, at least to get certain information, although he denied that. So I know your allegation is he was caught in a lie and everything else. But I guess I'm just wondering, and I know there were some excerpts in here from what the conversation, questioning from the court, but I'm just wondering, you say, well, you don't know how that influenced. Was any questions asked of any of him or the foreman as to whether he brought any outside information into the deliberations?
The jury was pooled, and they did. There were questions asked. However, there was discrepancies in testimonies of the jurors in regards that they didn't know when he had actually looked at the information and whether or not that information was given before deliberations, or whether or not they found out about it after deliberations.
But your allegation is, I'm sorry for interrupting, but your allegation is that you don't know if outside information, meaning information that was not presented in the record, was there anything that was asked the jurors that would disclose or that would refute that it was brought in or not, that it wasn't brought in?
There were questions to that effect, Your Honor. The only answers that we know that the jury is aware of is that he had said that these people were subpoenaed and that there were subpoenas issued. We don't know if there was more information outside of that, Your Honors. To that end, we don't know if the jurors themselves are aware, because a lot of people don't take notes during the trial, and they go back and they just rely on things that they've heard or something to that effect. So it's possible, and I'm sure it is just a possibility. However, when this juror went back and clicked on the information, it's readily apparent that he had gone more than just looking at the name, because you can't find out that there's subpoenas issued unless you go further. And to that end, we don't know if there was more documents that he actually reviewed and then started making arguments in the deliberation chambers. For that reason, he should have been dismissed and the alternate juror placed in. That's why we have alternate jurors in the court. Now, we have 12 regular jurors and the 13th for specifically that reason.
This was disclosed after they had come to a verdict, right?
It was. However, he disclosed it to the other jurors by accident, Your Honor. And then once he said that, then the jury foreman, he said, well, we have to let the court know this. So the jury foreman in and of himself knew that this was an issue. And by the jury foreman saying, hey, we have an issue with this, this could be something, where you were being dishonest or something to that effect, it shows that it could have tainted the jury. Otherwise, to that effect, the jury foreman could have just said, oh, well, it's not a big deal because you didn't look at anything. So the jury foreman obviously had some issues with the fact that this person had reviewed information that was outside the court bounds. If I may go on, Your Honors, the victim in this matter was repeatedly, if I could go back to the task endorsement of the court, was repeatedly offensive to the other counsel, to defense counsel, not answering his questions, being told that he would be held in contempt. However, he wasn't held in contempt until after the jury was dismissed. So it seems as if the court was allowing everything going forward, including his offensive comments to Attorney Simplin in this matter. Such an endorsement of the court shows that the jury could believe that the court believes that Mr. Hickman was guilty and that it didn't have any reason not to stem the tide of those defamations towards Mr. Simplin. Then the sentencing in this matter, Your Honor, I do believe that the court abused the discretion in going forward with the sentencing that he received. It's not commensurate with the other sentences, and I do believe that, if I'm not mistaken, Your Honor, that there was a statement that he had a lower sentence if he were to take a deal, and then the court went forward and gave him a greater sentence after the trial, which, in my opinion, is basically a trial tax, Your Honor, to that end. For those reasons, we believe that the court abuses its discretion in sentencing Mr. Hickman. Another issue is that the conviction was against the manifest weight of the evidence in this matter, Your Honors. There was at no point anyone who could identify Mr. Hickman other than a person who was repeatedly counterproductive to any argument with the victim in the statement. No other persons could put Mr. Hickman at the scene. The victim in this matter is someone who was contradicted quite often on the stand, and therefore his testimony cannot be reliable. And therefore, the Rule 29 motion to dismiss for insufficiency as to being able to prove the charges at the time should have been granted, and therefore it is against the manifest weight of the evidence. Lastly, the prosecutor in this trial repeatedly referred to Mr. Hickman as a drug dealer. There was never any charge against Mr. Hickman as a drug dealer. However, this was highly prejudicial. It was repeatedly asked by Attorney Siblett that the prosecutor not refer to him as a drug dealer. However, the prosecutor continued to do so, even in his closing arguments. And throughout the trial, he even evidenced that Mr. Hickman was a drug dealer and had rental homes, and therefore he distributed drugs through rental homes. However, there was never any evidence to this fact. It was just a mere opinion of the prosecutor, and therefore the statement of the prosecutor, by just putting it out there, taints the evidence and the discussions to the jury.
Well, I thought the victim testified that he was a drug dealer.
The victim testified that he was a drug dealer. However, the prosecutor in and of himself was making statements that this man is a drug dealer, referring to a drug dealer. However, there was no other allegations. And again, the biased witness of the victim could not be held to be persuasive in that matter as to alleging to this man from the prosecutor's position that he's a drug dealer, because there had never been any charges or anything that related to the court. And the constant view of the prosecutor, who holds a lot of sway in the court, of saying this person is a drug dealer, he's a drug dealer, he's a drug dealer, re-emphasizes it to the jury, and the jury therefore...
I presume there were constant objections to this.
Yes. There were...
And you're starting to rebuttal time if you want to keep that.
Thank you very much,
Thank you.
May it please the court, Heaven D. Martino on behalf of the state of Ohio, the appellee, we are asking that this court affirm Mr. Hickman's convictions as well as his sentence. Just to respond to the arguments and the manner that they were presented this morning, Mr. Hickman did receive a fair trial. There is no dispute that the victim in this case had less than professional behavior in court. However, the record also shows that defense counsel was also abusive. The tenor of the cross-examination of the victim in this case, while the victim's behavior can be seen as abusive, the defense attorney also told the victim at one point to shut his mouth, and the court had to remind defense counsel that it was up to the court to maintain control in the courtroom. The court did repeatedly admonish the victim, Mr. Flakes, as well, to check himself, basically behave properly in court. So there's nothing in the record to support Attorney Bache or Attorney Walsh's position that the jurors could have found in any way that the court was accepting Mr. Flake's behavior or in some way endorsing Mr. Flake's behavior or his testimony, because the court did repeatedly admonish Mr. Flakes and also had to admonish defense counsel. With regard to, and the court also asked with regard to the juror saying that he had looked up Mr. Hickman's name on the website. The court did ask that juror about it. The juror steadfastly said that all he did was look up the name. When the jury foreman said he thought that perhaps the juror also looked up whether there was a subpoena for Miss Henry, the court called juror number 2 again. The juror said he had not done that. The jury could have known about Ms. Henry and the fact that there was a subpoena for Ms. Henry, aside from this juror's alleged investigation into the subpoena, because it is not clear whether that actually happened, because Mr. Flakes testified, I believe it was on page 144, he said that he initially told the paramedics that he didn't know who shot him because of the G code, and that if he talked, he would end up dead, and he told his girlfriend, Donna Henry, to not appear at court so that nothing bad happened to her. So that information could have come to the jurors from that. It did not necessarily have to come from this juror, and the fact that the jurors were aware of that does not, ipso facto, mean that they got that from this investigation that juror number 2 did.
Let me ask you a question, because I was just curious in reading this. The juror that looked up the information indicated the reason he had done it was to try to find his name.
That's very strange.
How would you find somebody's name if you don't know their name?
I don't know, I thought the same thing. I had no idea why. I mean, I suppose you could have the case number, but why you wouldn't know the name, I don't know. This was not a very logical explanation, I'll give you that. But the judge presiding over the case was the one who would make that determination as to whether there was any prejudice. And even if that was a lie, that he looked it up because he couldn't remember the name, there still has to be some evidence that justice requires that there be a mistrial and that there was an impossibility to have a fair trial. And in this case, the burden would be on Mr. Hickman to show that there was prejudice. The court repeatedly asked, counsel to show some specific evidence or incidents of prejudice, and they could not do that. So therefore, they didn't show that there was a manifest necessity. Just a perception of prejudice isn't enough to have a mistrial.
I know the court admonished them that they're not allowed to do any independent investigation, but as you recall, did the court specifically tell them why that was necessary?
I don't recall.
Because we're just getting a bunch of these lately, so I'm just wondering.
That's true, yeah, I have seen a little bit more of that. I guess with the smartphones and things like that, people maybe don't realize that that's also research. I don't recall in this case whether the court specifically explained why or not, to be honest. But the court did ask every juror, and this was brought to the court's attention before the verdict was announced, but they already had deliberated, and every juror said that this information did not influence them in any way, all of the jurors. So there's no evidence in the record to show that there was any prejudice to Mr. Hickman with regard to what juror number 2 did. With regard to the sentencing, in this case, the prosecutor did put on the record during sentencing that before trial he had offered Mr. Hickman 6 years, and in part of his offer was based on the fact that if he pled, he would be showing some evidence that he was accepting responsibility, and it would prevent the victim from having to go through the experience again. That is in the record. What is also in the record on page 17 is that the judge had no knowledge of the negotiations in advance. So the court, when it imposed sentence, was not doing that to punish Mr. Hickman for not accepting the 6-year deal that the prosecutor offered. The court explained that the reason why she found that this was the most serious form of the offense and something that would indicate a likelihood to commit a future offense is because Mr. Hickman essentially chose to almost take a life for a thing. So the evidence was that Mr. Flake's injuries were very serious. There's some dispute as to whether he actually died, but he was definitely close to death. The paramedic testified that they didn't think that Mr. Hickman would survive, and the court found it a very indicative of a person who would commit future crimes, and also something that would show how serious this offense was, that over a stolen handgun, Mr. Hickman would choose to shoot somebody point blank in their leg while they were begging for forgiveness, begging for their life, saying that they would make it right, get the gun back, do whatever they had to do. And rather than do anything within the law, Mr. Hickman chose to shoot Mr. Flakes, almost causing his death over something as minor as a material object like a handgun. With regard to the weight of the evidence, there's certainly enough evidence in the record, if you believe Mr. Flakes, that this felonious assault was committed by Mr. Hickman in the manner that Mr. Flakes indicated. There's blood evidence in the places that Mr. Flakes indicated where he was shot and how he was kind of dragged to the door and out on the porch. Mr. Flakes testified that his girlfriend was there and she was screaming for help and hitting the house outside. The neighbor said he saw the screaming and the person hitting the door. He looked out, he saw a man on the porch bleeding out. He saw the figure of a female by the porch light. So there is evidence to support what Mr. Flakes is saying. But the issue of credibility is something for the jury, and the jury was aware that Mr. Flakes was a drug user. He admitted to that. And that was part of why the court allowed the prosecutor in the summation of the evidence that was presented to refer to Mr. Hickman as a drug dealer, because the judge, the prosecutor, and the defense came to an agreement that if the defense was going to have Mr. Flakes talk about being a drug user, then the court was going to allow the prosecutor to talk about the fact that Mr. Flakes got his drugs from Mr. Hickman. And that's reflected in the record on 399 to 400, 439 to 440, and 444. And with regard to sufficiency, Mr. Hickman he raises sufficiency, but he does not develop an argument. His entire challenge to the evidence for the felonious assault is based on the credibility of Mr. Flakes, and that would go solely to the weight. If there are no further questions, I rest on my brief.
President Beer, thank you.
Your Honors, if I may, rebut the issues of the sentencing in this matter. Your Honor, the court did not address the likelihood of recidivism at all when they were doing the sentencing in this matter. And further, Mr. Hickman did not have a violent history, and there's no evidence any violent crime would be committed in the future by Mr. Hickman. To that end, the court failed to apply all the issues they were supposed to when doing the sentencing. Further, although the court showed that, or stated that he showed no remorse for the action, Mr. Hickman was maintaining his innocence during the entire matter, and therefore, to maintain his innocence, he did not show any remorse in this matter. He's saying he's innocent of the crime. Therefore, it is unfair abuse of discretion for trial court to hold that against him when he's saying, I'm an innocent man, and they're saying, well, you're not showing any remorse. The court then imposed the maximum sentence and did not show that it was the worst form of the offense that could be committed. The person was shot in the leg, which shows an intent that he most likely did not mean to kill this person.
Well, it was a fairly serious wound, was it not?
It was very serious.
Very life-threatening.
It was. However, the injury that occurred if someone was with an intent to kill would more likely be towards the chest or low part. In this matter, it was a shot in the leg.
Assuming you were a good shot.
Assuming you were a good shot, Your Honor. Otherwise, to that end, the court did not show that it was the worst form of the offense, and again, did not show that the offender was likely to commit crimes such as this in the future, and therefore did not meet all the burdens they were supposed to set a maximum sentence in this matter.
Thank you. Thank you both for your presentations. The court will take the matter under advisement, and a written opinion will be sent to both parties, and you can check on the website. Thank you.